I'm never just going to give you something if I don't agree with what that is. That's not how we do things. So if that helps with that understanding, I'm gonna let you visit with Mr. Lewis again, and go over that, but it's definitely I don't do that. I never have, and I never would do that. I don't think that's actually the right way to do it. So, you're pleading guilty based on an agreement. And so if you don't take that agreement, or if I don't take that agreement, we'll start all over. And so, Mr. Smith, before you came out, Mr. Lewis explained that some of the hesitation you have, that there's an agreement that you guys have worked out that you're willing to accept, but you're a little concerned because Harris County does things differently, I think, than we do. I just want to let you know how we do things. And then if you want to enter that plea, you can. If you want to go to trial, you can do that, okay? What I do is if someone pleads to an agreed plea, I to take that plea today, and then I reset your case for sentencing. During that time period, I have the probation do a pre-sentence report just so that I have more information when we come back. If for any reason at that time, there's something in that pre-sentence report that makes me say, you know what, I'm not going to follow this agreement. And what I do is allow you to withdraw your plea of guilty, and then we start all over. You go to trial, or y'all work something else out. Again, you're Joshua Smith.
Yes.
And Mr. Lewis, will your client waive more reading of the indictment?
You do.
Mr. Smith, in cause number 25, DCCR 1439, you're charged with the first-degree felony offense of fraudulent use or possession of identifying information in the amount of 50 or more from August 20th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get that PSI done, and then we'll come back later for sentencing. Mr. Smith, what is your position with regard to bond based on that?
We're not opposed to a PSI bond on this, Judge. I believe there's a little bit of criminal history, but I think it'll be fine on this case.
So, Mr. Smith, what I'm going to do in your case is, based on the nature of your plea, is reduce your bond to $1,000. If you're able to make that bond, there's a couple of very important things about it, though. The first thing you do when you're released from custody, if you make that bond, is go to the probation department so you can get that pre-sentence report and started. You're going to get some information today, some paperwork, so that you'll know where to go. Also, if you bond, don't do that. If you don't show up, don't get that report done, you run the risk of me not accepting the plea agreement. If you're arrested for anything between now and when you come back, you obviously run the risk of me not accepting the plea agreement. And there's no, I was going to ask this a minute ago, there was no restitution or anything like that. All right, so you'll get some paperwork from probation this morning. If you make the bond, do everything you're supposed to. If for some reason you don't, they'll come out to the jail and do that pre-sentence report out there. Okay, see y'all back at sentencing. No.
Judge, what we're doing is pleading him to it's the same offense, deadly conduct, just under 22.05A, which makes it a Class A misdemeanor.
05. All right. Mr. Boyd, in cause number 25, DCCR 0720, the state has elected to proceed on the lesser included offense of a Class A misdemeanor of deadly conduct, and that's from March 20th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablets some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Jeffries? Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Boyd is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, defer all proceedings and place you on probation for 1 year. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have conviction on your record. And at the end of the probation period, if you successfully complete it, the case will actually be dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the county jail for up to 1 year. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's sitting at that desk right over there. She's going to call you up to her desk to go over all of your paperwork when she's ready. All right, good luck to you, sir. Thank y'all for working this out.
Thank you,
Thank
Judge.
you.
Thank you, Bill.
Yes, sir.
It's gonna be hard to get through a bunch of words.
Now
It's gonna be hard.
now I get to go meet the teacher.
Have fun. Harold Denton. Yeah, how are you? Yes. Have you ever been? Good morning. Good morning.
Sure, how many count you want him to leave to on that, judge, there's an agreement for 7 years TDC.
Okay, I'll take a look at the,
I'll waive any of them that you don't deem necessary.
hey, sir, are you Harold Denton?
Yes, ma'am. How are you?
Good, thank you. And, Mr. Lewis, will your client waive the formal reading of the motion?
You do it, Judge.
Mr. Denton, in cause number 21-37744, I have a motion to revoke the community supervision. Shows that you were placed on probation October 20th of 2021 for the offense of assault on a peace officer, a 2nd-degree felony, and that was a 10-year prison sentence that was probated for 10 years. Is that correct? This motion alleges that you violated your probation. It alleges in count 1 that you failed to report to the probation office as ordered September 26th, October 17th, November 13th, and December 1st of 2025. And is that true or not true?
True, Your Honor.
Count 2 alleges that you failed to immediately report your home address and phone number also to the probation office as required. Is that true or not true?
It's true, Your Honor.
Count 4 alleges, I'm gonna dismiss 3. Count 4 alleges that you failed to be placed on the mental health initiative caseload as ordered due to the fact that you absconded and you were unavailable for placement. Is that true or not true?
Yes, ma'am. That's true. I had
Count.
difficulties.
I'm sorry.
I had some difficulties. They stolen my medications from my backpack at the bus stop, and I just
Okay. Count 5 alleges that you failed to successfully complete the BIP program. Is that true or not true?
the what program?
BIP, the battering intervention and
This is true. Yes, ma'am.
okay. I think with the agreement, if y'all are okay, that's fine.
9 was the failure to complete.
There we go. 9, count 9 alleges that you failed to enter and successfully complete the Safe P outpatient aftercare. Is that true or not true?
Aftercare is from I successfully completed this. The
Right.
in-house system.
This is just the aftercare. You got to do the whole thing.
Yes, ma'am.
All right. Did you enter your pleas of true to counts 1, 2, 4, 5, and 9 freely and voluntarily?
This is true. Right.
And did you plead true to those counts that you pled true to freely and voluntarily?
Yes.
Okay. And I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Denton is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 4, 5, and 9 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, and at this time revoke the probation. Reassess your punishment in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff.
Yeah, he was on strike probation. He definitely beat that.
Well, his was in 21, and I think we started, I think it was 22 or 3 when I started reading it. So in my mind, if it was 22 or before, because I can't remember, I just do it again.
Yeah.
I can't remember the exact day. And, and I need to say so many more words today.
That's what I was looking at. Sounded like we only had you for a little bit more.
Yeah, luckily it's not a big day. Let's see. Perry Heard. Good morning. Are you Perry Heard Jr.? I'm sorry.
Right.
Okay, and this is cause number 26 DCCR 0052. Mr. Heard is charged with harassment of a public servant. We want to take judicial notice of the court's file. I received a report from Dr. Capon with regard to competency, and that report is dated June 23rd of 2026. The finding in the report is that Mr. Heard is competent to stand trial. Is there any other evidence with regard to competency?
No, Judge, not from the state.
Right, that at this time, based on that report, I am going to find that Mr. Heard is competent to stand trial. And what is the announcement?
Judge, I have received a new offer this morning since visiting with Mr. Hurd in regards to his offense, Judge, and I think it's something that could possibly resolve this issue. If I can just get a short reset in so I can explain that and go over with
Sure.
Mr. Hurd.
You want a week or 2?
About 2 weeks.
Okay, we'll reset the case 2 weeks, Mr. Heard. Mr. Lewis will be out there to go out and visit with you about all your options, and we'll get an announcement at the next court date.
This is the court date for today, right?
I'm sorry,
So this is my court date.
today's your court date, but I'm gonna move it for 2 weeks so that Mr. Lewis can spend some more time with you going over everything, okay?
All right, so I've been in there long enough to let's see if I need time served or how.
Talk to Mr. Lewis about all your options and he'll let you know what they are, okay?
Okay.
All right, he'll be out there to go over all of it and
So
make
this
sure,
is looking good for him.
I'll come
he'll be out there to go over all that, okay? You can go back with the bailiff.
I'm gonna talk to y'all whenever.
All right.
No problem.
Denisha McMillan.
Yes.
Morning, ma'am. Are you Denisha McMillan?
Yes, ma'am.
And this is cause number 26, DCCR 0647. And I'm going to take judicial notice of the court's file in Ms. McMillan's case. Ms. McMillan was evaluated for competency to stand trial by Dr. Capon. I received that report dated June 23rd of 2026. The finding in the report is that Ms. McMillan is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Judge.
Not from the state.
Then at this time, based on that report, I am going to find Ms. McMillan competent to stand trial. Mr. Lewis, will she waive the formal reading of the indictment?
She does.
Ms. McMillan, you're charged with a third-degree felony offense of injury to an elderly individual from March 16th, 2026. And how do you plead to that charge?
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
No, ma'am, I'm just ready to do my time.
Well, it doesn't work like that. If you didn't do this, then you get a trial. So here's the thing, before you go any further, when you stood over in front of the clerk a minute ago, you raised your right hand and you said you promised to tell the truth, the whole truth, right?
Yes, ma'am.
So if you're guilty, you're guilty. If you're not guilty, then we'll get your case set for trial, but I'm not gonna allow you to plead guilty with something you didn't do.
Yes, ma'am.
Okay, so if you want to talk to Mr. Lewis for a minute again, that's fine. If you're going to take responsibility, then I'll ask the same questions again, but that's going to be up to you.
Yes, ma'am.
What do you want to do?
I mean, I don't have anything to say with it. I know I never touched him.
Okay, so then I'm going to delete this paperwork, and what we'll do, Ms. McMillan, is I'm going to set your case for trial.
Yes,
When I set your case for trial, Mr. Lewis is appointed to represent you at this point. He handles a lot of cases for me here as a appointed attorney. With your permission, I can release him and I can appoint another attorney who could get ready for trial a little quicker. Is that okay with you?
yes, ma'am.
All right, then, Mr. Lewis, you're released. Ms. McMillan, we will get you an attorney appointed today. They'll be out to see you very soon to begin preparation for trial.
Yes,
All right,
ma'am.
you go back with the bailiff.
Yes.
And Mr. Smith, if you'll make a notation, make sure, obviously, that's. I mean, we'll see what the other attorney does, but I don't intend to keep that deal. I'm sure you don't either.
No.
All right, Kadesha Scott. Morning, ma'am. Are you Kadesha Scott?
Yes, ma'am.
And this is 26 DCCR 0797. Ms. Scott is charged with the first degree felony offense of aggravated robbery from July 3rd of 2025. And what is the announcement?
Judge, in this situation, we have the complaining witness who's evidently been trying to get in touch with the state
Okay.
in regards with this issue. And actually, I talked to the complainant myself a few times where they've called me saying they've called trying to get in touch with the office. I've given them their number up there so he can get that taken care of. That's the main weight that we
Okay.
have on our end.
Sure.
And Judge, I mean, in the meantime of that, of course, I would like to possibly either, I know we may not be able to take care of it this morning, but at least get a bond hearing set from Ms. Scott until we can get that worked out.
Let's do this. I mean, is there any reason you can't try to get that worked out this week to get in touch with them?
This is a case I inherited from Mr. Coleman.
Okay,
The number that Mr. Lewis has for him is the number that we have in the file. We did send him a letter. Tommy sent a different letter than we normally send, and it was returned. So I don't know about the address, but the phone number apparently is good. I didn't have a message that he had called, but I will reach out to him.
Okay, let's do this. I'm gonna reset it 2 weeks and that'll give Mr. Smith time to kind of get caught up, make that phone call, get in touch with them. If by that time, between now and then, if you want to go ahead and file a motion for bond reduction, that way everybody's on notice and we can have that hearing on that date if something else doesn't get taken care of.
Good.
Okay, all right, see you back in 2 weeks. Joshua Smith,
Can you speak to when you come?
yeah, hold him for us.
True. Find sufficient evidence to revoke your probation, and at this time revoke your probation, sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You'll also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You will, these cases will all run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in each of these cases that shows that these were agreements that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank y'all. What you need? Y'all need some? Yeah, I can just give me this. Okay. Bailiffs already know. Okay.
Damn.
It's preset up here. Just.
Amanda Arendt.
Judge, we're gonna, that's, the state is asking that we reset that. It's Ms. Malfino's case. She's trying to talk to somebody about, I don't know, to give me an offer.
Okay,
She's asked us to reset.
we'll just do one normal reset on that. Kyla Allen, it's a sentencing, Mr. Parker.
Yes, Your Honor. No, she can go back. I told you already. Kyla Allen. For sure. So, oh, you gotta get their level of argument. You know.
All right, ma'am, are you Kyla Allen?
Yes, ma'am.
And this is 23 DCCR 0639. Ms. Allen was placed on probation October of 2023 for evading arrest or detention with the use of a vehicle. In court previously entered pleas of true and a motion to revoke probation to counts 1 through 10. I've received that updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
State has just,
Are there any additions or corrections to that report?
No, Judge.
not from the state.
And this is unagreed. Mr.
Correct.
Parker, you may proceed.
Your Honor, all I can say is, these violations are all technical, even though, I understand that they're still serious and you have to follow the rules of probation. She's young, she's 19 years old. I think being in jail has opened her eyes. and she wants to complete probation. She has quite a bit of time behind this, and my deal was, take the time. She said, I don't want to do it. And she's sincere. She says, I want to prove to myself and prove to everybody else that I can complete the probation. And she has the opportunity. She has a job waiting for her. She gets out, and she's requesting this stay on probation, and she'd like to address it for the judge.
Go ahead, ma'am.
I just want to say I own up to all my wrongdoings. I do. I know it was wrong. I knew it was wrong when I was doing it, and I regret it, but I want to prove that I can do better, and I'm not the person that I got to be. I'm young. I want to build my relationship back up with my people, make it stronger, build my trust. Just do the right thing, make it right before it's too late.
Thank you, ma'am. Mr. Coleman?
Your Honor, this is Mr. Smith's case. I'm under the understanding that Mr. Smith made a 3-year offer in this case. I am cognizant of the fact that recommendations from probation department on the last page states that while the defendant's violations are mainly technical in nature, this officer is not inclined to recommend continuation of supervision at this time. So with that, my position is the same as Mr. Smith, that shooting results in some jail time.
Ms. Lopez, do you have anything to add other than what's in the update? So, Ms. Allen, the only thing that I'm inclined to do if I continue, I mean, you are young. You don't have a lot of criminal history. This is your first felony, no misdemeanors. Of course, you're young, but you were actually certified as an adult for this, which is, I don't know, certifying on an evading is a little, I guess it's because she was so close to age, but still that's. So here's the thing. You're not going to go home today. Okay. If I continue you on probation, which you don't want a felony conviction. At this age, it changes your life in a very negative way, but you obviously need some, in my opinion, just a little more help to make better decisions. And so what I'm going to do is find that you entered your pleas of true to counts 1 through 10 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and send you to prison. I'm not going to do that today. I'm going to continue you on probation, but I am going to order that you now enter and successfully complete the cognitive track of the ISF program. So you went to the substance abuse track so that you could get tools to stay clean. This track helps you make better decisions, helps you grow up. It's hard at 19 to make the decisions that you need to make to be able to stay on this probation, and this is meant to help you. And so you'll go from jail to that program, you'll get out, you're still going to be on probation. You will be on 0 tolerance probation. That means if you make another mistake, Ms. Lopez is going to send something over. There's going to be another motion. I'm going to look back at this. Mr. Coleman and Mr. Smith are going to remind me that they asked for prison time this time, and it's probably not going to be the 3 years. Do you understand?
Yes.
I hope you take advantage of this opportunity. All right. Good luck to you, ma'am. You can go back with the bailiff. Come back for a second. Well, I just want to make sure of something else. I want to make sure you understand something else. That if you get incident reports in our jail or in ISF, that will be a violation of your probation. And you may not ever make it to ISF. So if you are you're going to say things to the correctional officers, not do what they say, and tell them that you don't care about getting a write-up, but say those things in a lot worse ways, then you're going to go to prison, and you're not going to go to prison for 3 years. They're just there doing their jobs. If you follow the rules, they'll probably leave you alone. If not, their job is to make you follow the rules. And if you can't follow the rules in our jail, then I don't assume that you can follow the rules on probation, which you're kind of showing a pattern here. So it's time to grow up, change all that, or you're going to prison. It's that simple. Understand? Okay, go back with the bailiff. I don't know how I did that. Okay. Bobby Clark, Mr. Parker.
Rejection. Cheers. It's rejection. My wife's been home 24 hours in 4 weeks. She sent a text to one of our friends. She said, I don't know when I'm coming back to New York. She's serious. She's serious.
You're like, hello?
I mean, being a bachelor's not easy. I'm telling you.
You're gonna
I'm
have
not
to.
very good at sitting at home by myself.
Yeah.
I have to go.
That's not a good thing either.
No.
Good morning. Are you Bobby Clark? Speak up, please.
Yes, ma'am.
And Mr. Clark, in cause number 25, DCCR 0802, you're charged with a second-degree felony offense of indecency with a child by sexual contact from March 10th of 2025. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And I have here on the computer a plea bargain rejection that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 4-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? Speak up.
Hold just a second, Judge. Yeah, this is what I'm.
Oh,
12.
I screwed up, Judge.
4 is 12.
He had 4 here. It's 12 years. And I didn't, well, I'm assuming you're going to want to reject that.
Okay, so
But I didn't know.
I was wondering.
Yeah,
Make
you
sure,
had-
no.
that makes sense. I was telling, I think it's a very good offer.
It was, yeah.
Yeah.
That was, apparently that was his old case and I didn't see down below where he.
Okay,
I didn't
so,
see the bold.
so Mr. Clark, the offer in your case is actually 12 years. And I'm assuming since you wanted to reject the 4 that you want to reject the 12. Is that correct?
Yes, ma'am.
And so again, I just want to make sure you understand the possible consequences if you go to trial and they're found guilty. The punishment ranges between 2 and 20. The option right now is for a 12-year term in prison if you wanted to plead guilty. Do you understand?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, I will get that done. Is there any reason to believe that that offer would change? So I want to make sure also you understand that after today, unless there's some new information that comes up that the lawyers don't know about, I will not accept this plea agreement. You understand? Speak up, please.
Yes, ma'am.
Okay. And so, Mr. Clark, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint a new attorney who can begin preparation for trial a little quicker. Is that okay with you? So, Mr. Parker, you're released. Mr. Clark, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, you go back with the bailiff.
Thank you.
Mr. Matuska, Vonzell Hall. Morning. You working on the other one? Are you doing paperwork on Garner still? Huh?
We've got it, Judge.
Oh, y'all already done it?
Yes, ma'am.
Okay, I see. All right, perfect. Vonzell Hall.
I missed the opportunity to tell you, I told you so earlier. I really regret it.
Did you?
It was a cap and they got permission and we revoked it today. Me too.
You should, you've got to take advantage of those
I know,
opportunities.
that's it.
I give them to y'all, so.
But it also was like maybe Ashley wasn't mad, so I didn't tell you, so. So I really shouldn't claim it.
It's okay. You're here for her. Good morning. Are you Von Hall?
Yes, ma'am.
And Mr. Hall is charged with the offense of murder in cause number 24, DCCR 1747. And what is the announcement?
Your Honor, we've received a plea bargain offer, and that we've been unable to reach an agreement on that offer.
Okay.
And I've informed Mr. Hall of that offer today. It actually has come down a bit, but I've updated him on that. Again, we haven't been able to come to an agreement.
Okay.
And I see no reason why it would come down any further, Your Honor.
Is that a new rejection that
Yes,
you
Your
have? Okay, if y'all will sign that so I can get it over here and that way I have that. What's the offer?
It's 35 years.
So Mr. Hall, if you don't want to take that offer of 35 years and you want your case to go to trial and let a jury decide, sign that document real quick and then we'll get it set for trial.
And Your Honor, this is not a cap. This is straight.
Okay. Well, your options are to take 35 years in prison or to go to trial.
So if I sign this, I'm accepting it?
No, if you sign that, that's the rejection that says you want to go to trial, that you don't want the 35 years. If you want to plead guilty and take the agreement for 35 years, there's some different paperwork y'all can do this morning and we'll get that taken care of. But if you don't want to take that offer, then we'll let a jury decide.
And I don't know if it's on that rejection, but I did discuss a possible 40-year cap with Mr. Matuska. If he wants to talk about that.
Do you want to talk?
I told you that.
So either you want to take the 35, take a 40-year cap and let me decide. I could give you 40, I could give you less, or let a jury decide if you're guilty and what your punishment is. That's your options.
Reject that or discuss it?
Take a 40-year cap.
Okay. Well,
Yeah, I'll go do that paperwork. I'll hold it for the paperwork then. So I'll delete this. Oh, wait, there wasn't anything. You can
No, they
delete it
hadn't
on your,
sent it
y'all
to me
hadn't sent it
yet,
yet.
so-
Okay, I'll hold it then. Let me, well, Mr. Matuska, I'll let you take care of that and then I'll do Garner in that one when you're finished, get you all taken care of. Let's see. Ms. Holmes. I don't, oh, did he? Let's see. What was that on? Gabriel Smith. It's here. Mr. Kimler on Gabriel Smith. Gabriel Smith.
I think this one we did.
I know, I need to do the rejection.
Oh.
Yes, please, ma'am. Okay, again, you're Gabriel Smith. And Ms. Smith, in cause number 25, DCCR 0979, you're charged with a second-degree felony offense of assault on a peace officer from June 10th of 2023. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes.
Judge,
And I think-
nothing's been filed at this point, but I know with the number of priors she has and a note on the file that the priors have been ordered, I do anticipate there'll be a notice. I forget if it's Mr. Smith or Mr. Muffin, but I know they intend to enhance it.
So I want to make sure you also understand, and I'm going to make a notation on here. If any of those prior offenses out of Louisiana, the felonies, were at different times, and one conviction happened and then another conviction happened later, that means you could be considered a habitual offender and with a minimum punishment of 25 years in prison, up to 99 years or life in prison. Do you understand?
Yes,
Also, just in case they're not one after the other, if you have one prior felony conviction, then, okay, it doesn't do anything. Right, this is a second. All right, so if you have two sequenced, it would make you habitual. Do you understand?
If she has one, it would boost her up to a first.
Yes, sorry. I just, so if you have one.
not understanding what they mean.
Okay, so listen very carefully. You have several felony convictions out of Louisiana. Okay, so if just one of those is true, then your punishment range in this case, if you're found guilty, becomes that of a first-degree felony instead of a second. So that means it would be from 5 years minimum up to 99 years or life if there's one prior conviction. You understand? Answer out loud. So the,
Yes, ma'am.
okay. If there's two prior felony convictions that happened, not all of the, I know there were several that happened at the same time, right? But I'm not sure, but it looks like there might be another set that happened later. If that is true, and there are two that happened at different times, then it means you could be considered a habitual offender here in Texas. And if that all is true and you're found guilty, then your minimum punishment is 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
Okay. And it looks like what the state has offered, if you wanted to enter a plea of guilty, would be to go on count one, which is just the offense that you're charged with now, for an 8-year term in prison. You have every right to reject that and have your case go to a jury, let them decide if you're guilty or not, and then let them decide your punishment depending on what they find on those priors. I just want to make sure you understand what your options are if you wanted to plead guilty for that 8 years and what your possible consequences are if you go to trial. Do you understand all of that? Okay. And do you want to reject that offer and have your case set for trial?
Yeah, I want to reject.
Okay, and I do want to make sure you understand, Ms. Smith, that after today, unless there is new information or evidence that comes up that the attorneys don't know about at this time, I will not accept this plea agreement after today. So if you change your mind, it's not going to be to the 8 or something less later. It's going to be something different. Once a case goes on my trial docket, it goes to trial. So it's not, we're buying time to try to get some better deal. This is the deal. That's fine that you don't want to take it. I do want to make sure.
I haven't, so I can't think on it and come back.
You can think on it and come back next week.
Okay, that's fine.
1 week, you'll leave it open?
Yes, Your Honor, I'll leave it open for.
You have to decide by next week, knowing all of that. Nothing's going to change between now and then. So now you know everything. Think about it. Talk to any family members that you need to. We'll have you brought back next week and you can decide, okay? I'm going to delete this rejection. If y'all do it again, you'll have to do it again. Okay? All of her, if you want to see that old PSI, it's got all those listed. We could get you a copy at least of that page, I'm sure.
I had a real question on, with Louisiana, felonies are the judgments, so sometimes the judgments are problematic for Louisiana. It depends on which parish.
Okay. Well, y'all figure that out. Do you need more time than a
No,
week?
ma'am, that's fine.
Ms. Holmes, you're sitting over there so quiet in the corner. I didn't even see you. You've got LaKendris Addison.
Yes. Good morning.
Good morning. Let's see, this
Judge,
is a motion.
We have an agreement on this case.
Okay.
On count one, I'm gonna drop January 2022, February 2022.
Hold on half a second.
Oh,
Let me
sorry,
get that pulled up so I can make those. Okay. Count one.
And if it's okay with the court, we can proceed just on count one, but I was gonna drop the January of 2022 and February 2022. He was taken into custody in Louisiana during that time, Your Honor.
Okay, gotcha. Okay. Good morning. Are you LaKendra Addison? And Ms. Holmes, will your client waive the formal reading of the indictment?
He will, Your Honor.
I'm sorry, the motion.
Yes, ma'am. Yes, ma'am.
Mr. Addison, in cause number 21-36633, I have a motion to revoke your community supervision. Shows that you were placed on probation September 15th of 2021 for the offense of burglary of a habitation. And that was a 10-year term that was suspended and you were placed on probation for 10 years. Is that correct? And then count one alleges that you violated your probation and the state has amended that. Count one alleges that you failed to report as directed to the probation department October 5th, November 3rd, and December 2nd of 2021. And is that true or not true? True or not true? Count two alleges that, oh, I'm sorry, you going
If
on
it's
just
all-
count one?
We can, Your Honor, if it's
Okay.
okay with you.
State abandons 2 through 5. Did you enter your plea of true to count one freely and voluntarily? And because it's actually true. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney, you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Addison is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of true to count one freely and voluntarily. Find that count true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Let's see. I gotta figure out how to do, the other day I figured out how to do a strike through. I gotta figure out how to do that again.
Ma'am.
Toy Hill.
Your Honor, I think it's 35 miles of cat. Right.
Toy.
Mhm. Good morning. Are you Toy Hill? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Hill, in cause number 25 DCCR 0650, you're charged with the third-degree felony offense of assault on a family member by impeding breath or circulation from January 24th of 2025. And how do you plead to that charge? January, did I say February?
You said January 24th.
January 24th, 2025.
Yeah.
Is that, are you guilty or not guilty?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
I did.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
And do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've made is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years.
Yes.
You would be ordered to pay a $500 fine and follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Hill is not competent?
No, Your Honor.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Coleman, what is the state's position based on the nature of the plea agreement with regard to bond reduction?
Just for the court's information, I show a criminal history that includes a 4-year deferred on an injury to a child and a simultaneous violation of a protective order for 1-year probation, and assault, which was a misdemeanor, for resisting, and a theft, misdemeanor. I would have some concerns.
What is your relationship now with Cheryl Johnson?
That's our mother.
It's real good.
Okay, so let me ask you this. If you are released, when you're released from custody, where will you live?
With a friend of mine. My name is Tanya. 4555 Reed Road.
Reed?
Reed, R-E-E-D.
Uh-huh. And where's that? What city?
Off of, Highlands, it's off of Highlands. It's Reed Road, but it's in Beaumont, Texas.
It's in Beaumont. Because I want to make sure you understand that, at least for now, when you get out, you will not be able to have any contact with your mom, okay? And that's going to be very important, because if you do, if I let you out while we're waiting on the pre-sentence report and you have contact with her before we ever come back for sentencing, I don't have to accept this agreement, and things could be a lot worse. Do you understand? It's very important. So what I'm going to do, Ms. Hill, based on the plea agreement, is reduce your bond to $1,000. Okay, if you make that bond, you have a condition of that bond that you have to live at 4555 Reed Road with your friend. And if there's something changes and you need to live somewhere else, get with Ms. Holmes so that we know that. It is also a condition of that bond, if you make it, that you have absolutely no contact or communication with Cheryl Johnson. That means in person, obviously, but for now, that also means any contact, communication. Don't send her messages, don't text, don't email, don't Snapchat, don't, whatever it is, no contact. You understand? Okay. Even if she tries to say, it's okay, let's talk, I want to talk to you, you have to say no, because you're the one who will end up back in jail. Okay. So if for some reason you don't make that bond, probation will come talk to you at the jail. And then when you come back for sentencing, you would be released then. If you make that bond, then you also have to go straight to the probation department so they can do that report. So it's important that you do everything. They'll talk to you today and give you that information of where to go and all of that. Okay. All right. You can go back with the bailiff. Can win, Ms. Holmes. You good over there? Good morning. Are you Can Win? Will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Nguyen, in cause number 25, DCCR 0750, you're charged with the second-degree felony offense of burglary of a habitation from April 29th of 2025. And how do you plead to that charge? I'm sorry?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for an 8-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Nguyen is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what's the state's position with regard to bond reduction?
There's quite a few misdemeanors, Your Honor, for burglary of vehicle and trespass, among a couple other things. We don't see any other felony cases. This burglary is against property owned by his mother. I don't believe it was her residence. I believe it was the place she owned. He went there and essentially stole TV. So I do have some concerns, but his criminal history is not particularly extensive, Your Honor.
Just sounds like it's some of the same things, though, that I have some.
Correct. It's mostly burglary, several burglary vehicle charges, several trespass charges.
All right, I'm not going to adjust the bond at this time, just in case I want to do something up front based on that misdemeanor history. All right, we'll get the pre-sentence report, and then you'll get sentenced at the next court date. You can go back with the bailiff.
Thank you, Your Honor.
Thank you. Two cases are called on Courtney Wiley. Those are both MTRPs. If you'll do the second one.
Judge, just so the court knows, because he was just asking, it looks, there's almost all of those misdemeanors are from about 15 years ago, except for a trespass last year.
Okay, come
So I
back.
just wanted to make the court aware of that.
All right, so here's what I'm going to do. Mr. Nguyen, I am going to reduce your bond in your case based on your plea agreement to $1,000. If you make that bond, a condition of it at this time is that you have no contact with your mom. Okay, you cannot go near her, any of her properties. Do you have a place to live? With your brother? Okay, so now there may be a time when you can have contact, but at this point, because she's the victim in this offense, you are to have no contact, no communication. Obviously, that means in person, but it also means sending messages or text or anything like that. Do you understand? And what'll happen if you make that bond is the very first thing you need to do is go straight to the probation department so that they can do that pre-sentence report. If you don't do that, then you run the risk of me not accepting the plea agreement. Things could be worse. Do you understand? Okay, you can go back with the bailiff. You have both of them? Thanks. Okay, Courtney Wiley. Good morning. Are you Courtney Wiley?
Yes, ma'am.
And will your client waive the formal reading of the motion in each case?
Yes, Your Honor.
Ms. Wiley, in cause number 22-40872, I have a motion to revoke your community supervision. Excuse me. It shows that you were placed on probation March 1st of 2023 for the third-degree felony offense of harassment of a public servant in a correction or detention facility. And that was a 5-year sentence that was probated for 5 years. Is that correct?
Yes, ma'am.
And then in cause number 22-40873, I also have a motion to revoke your community supervision. This shows you were placed on probation March 1st of 2023 for the third-degree felony offense of evading arrest or detention with the use of a vehicle. That was also a 5-year sentence that was probated for 5 years. Is that correct?
Yes, ma'am.
Each of these cases allege that you violated your probation. Count 1 in each case alleges that you were arrested for the offense of public intoxication June 22nd of 2025 in Jefferson County. And is that true or not true?
Yes, ma'am, it's true.
See, that's another one. Count 2 alleges that you provided a urine sample June 23rd of 2025 that tested positive for cocaine and marijuana. Is that true or not true?
Yes, ma'am.
True or not true?
It's true.
Thank you. Count 3 alleges that you failed to comply with the program guidelines and rules of the Safe P Aftercare program. Is that true or not true?
Yes, ma'am. It's true.
And we can stop there, Your Honor.
Did you enter your pleas of truth, thank you, to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am, I did.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed those, did you go over them with Ms. Holmes?
Yes, I did.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tender's number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Wiley is not competent?
No, Your Honor.
All right, ma'am, I'm going to find in each of your cases that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 22-40872, find those counts true, find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 22-40873, also find counts 1, 2, and 3 true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. I'm going to hand you in each of your cases the trial court certifications that shows that these were agreements that I followed, so you have waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes.
Okay.
Good luck to you, ma'am. You can go back with the bailiff. Latrick Williams, what are we doing on Latrick Williams?
Remind me more time, that was Phillips, and I hadn't had a chance to talk to
Okay.
Phillips.
All right, I'll reset Latrick Williams, and if you need something and Philip's still out, just get with Ms. Malfino or Mr. Coleman or Mr. Nichols. I'm sure they can stand in and help you out with that if he's still out. Okay, Mr. Matuska, on Bonzel Hall, let's do him first. It may help me on Garner. Depends, the ones that he's pleading on Garner, it may be helpful for me since there's several to have the indictments printed, please. Okay, again, you're Bonzel Hall, correct? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Hall, in cause number 24, DCCR 1747, you're charged with the first-degree felony offense of murder And that is from, hold on a second. August 10th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Matuska? The papers on the computer that you just signed, did y'all go over those? Did he explain them to you? And do you understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like y'all have decided not on the cap, but on the,
That's correct, Your
Okay.
Honor. And despite what he said earlier, we changed our mind to
Okay.
the original 35%.
all right. Do you understand also, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. It's admitted. Is there any evidence that Mr. Hall is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of murder. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Matuska. You also should thank Mr. Matuska, because he worked out an excellent deal for you on this type of case. And I can assure you, if you had gone with the cap, things would have been a little bit worse. Do you understand? Go back with the bailiff. Xavier Garner. Oh, I just did it. Just made the noise. All right, there's 3 of them, it looks like.
We'll have 3 cases, Your Honor.
Yeah,
It's only on 3 of them?
The others will be dismissals.
I'm sorry, 2324, I thought y'all could still see it. 2324, 0890, and 0891. And then 2324 is the only other one I need, and also a copy of that sex offender registration, please, on that case. I can, I got that, never mind. I just need the indictment. All right, are you Xavier Garner? And Mr. Matuska, will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Let me look at something real quick. Mr. Garner, in cause number 25 DCCR 0891, you're charged with a second-degree felony offense of robbery. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? In cause number 25 DCCR 0890, you're charged with a third-degree felony offense of obstruction or retaliation from June 3rd of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then finally, in cause number 24, DCCR 2324, you're charged with a second-degree felony offense of indecency with a child by sexual contact, 5th of 2019. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In all three of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Matuska?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And then finally, in 24 DCCR 2324, that's the indecency case, I have here a sex offender registration requirement form that looks like it has your signature with Mr. Matuska's. You understand that as a result of this plea, you will be required to register as a sex offender, right? All right, state tenders number 1 in all 3 cases.
No objection.
It's admitted in each case. Is there any evidence that Mr. Garner is not competent?
No.
All right, sir, I'm going to find in all 3 of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 25, DCCR 0891, find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of robbery. Sentence you in accordance with your agreement to a term.
This courtroom session took a serious turn when a defendant appeared before the judge on a deadly conduct charge. The prosecution agreed to proceed on the lesser-included Class A misdemeanor, and the defendant entered a guilty plea. The judge carefully confirmed that he was pleading guilty freely and voluntarily, that he understood the documents he had signed, and that he understood the consequences of accepting the agreement. Under the deal, he received 1 year of deferred probation and a $500 fine. The judge explained that this was an opportunity to avoid a conviction on his record. If he successfully completed probation and followed every condition, the case could ultimately be dismissed. But the judge also made the consequences very clear. Violating probation could bring him back to court, result in a conviction, and expose him to up to 1 year in county jail. The hearing became much more serious when Harold Denton appeared for multiple probation violations. He had originally been placed on 10 years of probation for assault on a peace officer, a second-degree felony. The court then went through several alleged violations, including failing to report to probation, failing to update his address and phone number, failing to complete required programs, and failing to complete outpatient aftercare. Denton admitted that the violations were true. The judge accepted those admissions, found sufficient evidence to revoke his probation, and imposed the punishment agreed upon by the parties, 7 years in the Texas Department of Corrections, with applicable credit for time already served. The judge then gave him another important warning, explaining that because of the judgment, he was prohibited under Texas law from possessing